A very good morning to one and all. Today marks the 75th session of our study circle meetings. For today's session, we have Dr. N.V. Badarinath, former PO of DRT Chennai. He will be speaking to us on pleadings in civil suits. I now welcome Mr. Sivashanmugam, advocate, to render the welcome address.
Good morning, friends. We welcome you all to another session to be given by the very knowledgeable person on the topic of pleadings in civil suit. This is going to be the first part of the series of lecture to be rendered by Dr. N.V. Badarinath. Dr. N.V. Badarinath has acquitted himself well as the PO of the DRT, and his judgment speaks volumes about his knowledge. And with this short introduction about the speaker, I welcome him.
Thank you, Mr. Sivashanmugam. And thank you, the organizers, in particular, Mr. Om Prakash, for giving me the opportunity of sharing some of my random reflections on the topic chosen, pleadings. Well, friends, when Mr. Om Prakash had asked me whether I'm willing to speak on this topic, am I audible and clear? Fine. Without even considering my limitations on the topic, I readily accepted it. The reason being that I've been missing the lawyers of Chennai for the last 3 months. Exactly on 23rd February 21, I demitted my office as a PO DRT1 Chennai. Since then, every day I feel the absence and of many lawyers whom I used to interact, listen to their wonderful arguments, share their general views, discussions, and everything. So that was the sole criterion for me to accept it, rather than my ability to speak on the topic. Well, friends, having accepted the topic, well, it is my responsibility to do justice to the topic and meet the expectations of the people who are present in today's meeting. But let me tell you one more thing before I jump to the topic. My address is to the young lawyers, like the young lady lawyer who had commenced the proceedings today, and not to the seniors who are present here. And I know my limitations in meeting the standards that the many seniors who are present in the meeting, I don't think I would be able to meet. But I will try to meet the expectations of the young lawyers whom I always focus, for whom I always have the concern, as I consider them as the future of this legal profession or the institution itself. Therefore, I again remind all those listeners that my lecture will be for a new entrant or an entrant of not much standing, and a person who is practicing on mostly on the civil side. Before I pause again once before I go to the topic, pleadings. As I plead with folded hands before all of you to stay home as far as practicable. When you go out, wear double mask, as the risk has doubled today due to the second wave. And please cooperate with the government and the institutions in averting the third wave and a situation of wearing 3 masks. So it is in our hands. So this is my pleading at the foremost before I go to the topic, the technical pleading that we all now have assembled to discuss. Well, now this a topic being pleading in civil suits. I think the moment we talk about the pleading, it invariably refers to the civil suits only. The reason being, if you go by the definition of pleading in terms of Order 6, Rule 1, plaint, pleadings means plaintiff a written statement. Why I felt that pleading mostly, if not always, refer to a civil proceeding. The plaint, which is the word plaint, or the document that is presented in a civil list before a civil court called plaint, is used only in civil proceedings. The word plaint is not used in other proceedings, though they are either partly civil or quasi civil or commercial proceedings have a trappings of a civil suit. So our discussion, since is confined to a plaint, and I said the word plaint is used broadly in connection with a written list presented before a civil court, I would confine myself to the relevancy importance of these pleadings in a civil proceeding called a suit, defense, a countersuit, and a defense, which is instituted before a civil suit. Now, at this moment, maybe it is relevant to know what are civil suits, because a suit in particular is not defined. In fact, a suit is a process, because we don't have a oral application insofar as the institution of the list itself is concerned. Though at the interlocutory stage, oral applications are entertained and allowed under law, a suit is, though not defined specifically, it has got certain facets required to be complied. So, can a suit be instituted before any court? If instituted, whether a suit which is not a civil suit can be tried. Now, this is the foremost question that may require our what is called our focus at this minute, in brief, before we go to the topic. Because unless we identify the matter as a civil suit, discussion on pleadings may not be of much relevance. Therefore, everything that we present in a civil court, can we call it as a civil suit? And when can we call a civil suit? Now, see, there is a difference between a suit and a civil suit, in my view. Please refer to, if it is possible, I request the organizers to refer to section 9 of CPC, because we would start with the very, yes, section 9. It's a brief one. I will read for the benefit of the listeners here. The court shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. So, if you see, try all suits of a civil nature. So, unless it is a civil nature, though it may be called a suit, a civil court cannot try that suit. So, we have to keep in mind that the pleadings that we are talking about or we are going to discuss about is in respect of a suit which is civil in nature. Now, you will have an elaborate discussion on section 9. Elaborate commentary on section 9 once you read the commentary on section 9, because that is not much required at this stage, therefore I'm not going into. But suffice if it is noted that unless a suit which is instituted in is of civil nature, then the cognizance, right? Then civil nature, then the what we call this application of Order 6, Rule 7 in its strict sense or its entirety cannot be attributed with all authority. It again depends on the statutory terms of the statute under which that particular list is instituted. For instance, if you ask broadly what is a civil suit, what is not a civil suit, a civil suit is one which is not a criminal complaint. Like what is movable property, which is not immovable, as defined in the Transfer of Property Act. So, that by itself will not solve our issue, merely because it is a civil in nature. For instance, take an original application before a debt recovery tribunal. It is definitely not a criminal proceeding. It is quasi, it is not strictly a civil. It is quasi judicial, quasi civil. If it is a quasi civil, then it is a suit of civil in nature, if not in its entirety. But there is no reference about a plaint. There is no reference about, though there is a reference about written statement. There is no reference about plaint in the RDB Act. So what is, whether in such situations, whether Order 6, which deals with pleadings, is applicable in its strict sense, we need to see now. Nextly, take a proceeding before a family court. Act 5 of 1908, which is also called the CPC, application is nevertheless is no doubt there, but to a limited extent. So whether an original petition filed before a family court and the reply statement filed before a family court, whether require strict compliance of Order 6 Rule 7. Like this, several questions do crop up that we would discuss in detail little later. Now, let us first start on the premise that we are talking about the relevancy and importance of pleadings in a pure civil suit, like a suit for recovery of money, suit for injunction, suit for declaration, suit for title, specific performance, etc. Like that. Now, let us first start with the origin of this process. You see, when a civil right is infringed, or a dispute which is called civil in nature, and a person is aggrieved by it and wants the grievance be redressed, then he need to make in writing his representation, his complaint, and present it. Well, if it is a criminal dispute, then one would go to the police station, and basing on the complaint, the FIR is registered, a number is given that everyone knows, even a common man knows. Any criminal action is required or a criminal complaint is to be made, he has to go to the police station and make it. But in case of a civil dispute, we rarely find a person filing a plaint in a civil suit, as mostly it is done through lawyers. So, when a person who goes to the police station and makes a complaint is called complainant, a person who wants to redress his civil dispute through a court of law is called suitor. A suitor is the person who presents his grievance in writing by himself or through a qualified person like an advocate. And that is called the plaint. The complaint that you are talking about in general will be called as a plaint. And then that plaint, when it is presented, can it be presented in any manner one likes? To my knowledge, when a criminal complaint is presented, it need not contain the full details. Like we give the basic or the crux of the grievance in writing or even orally before a police officer who can reduce it to writing and make it an FIR and investigate and make a detailed charge sheet. Then file it and for the accused to defend that charge. See the difference in civil. The author is the advocate mostly, and the person instructs is the client. Then if what client says, my property has been encroached by my neighbor, I tried to stop, I negotiated but failed. Now I want my encroached property back. That is what he gives. He won't give us the sections. He won't give us the case law. At best, he would give his document saying, this is my document, this is my boundary, and is it that the other side is boundary. Now you can see whether he has encroached or not. He can give only that much of factual, bare factual information. Then if you write that and present it, will there be a chance of the client getting the justice? He may deserve justice. It may be a case where there is a real encroachment, but at times the client would be denied or even deprived, I would say, that relief by the courts for non-compliance of certain important procedural aspects. Here comes into play the pleading. Remember, the most important stage in a list is not the trial, not your arguments, not getting an interim order. It is the stage of institution of a suit. Because your client would only give you the instructions as regards the bare events or the facts and gives you the bare documents that he is in possession of. Then beyond that, he expects you, or he would expect, basing on this information, he would get justice through you. So you have the vital role, and your role of presenting his case is regulated by law. That is what Order 26 and Section 26 and Order 6 and Order 7. Here comes your role. The very inception, the very foundation. So you are now given an opportunity, or you are confronted with a task of safeguarding the interest of a client who comes to you with a grievance that he lost a bit of property on account of encroachment, or he is unable to recover his money from the person to whom he had given. So, friends, please understand that many people think, oh, this lawyer had made an excellent argument, wonderful argument, right? That argument may, at that stage of hearing, looks very attractive, very colorful, very interesting, and very convincing at times. But you, as a listener, perhaps I say, may not be knowing whether this argument is supported by a pleading, by a cross examination, by a document. Pleading, cross examination, document, the stages. Unless it is so supported or supported so, it's only an attractive argument. So always be focused on this. Now coming back to 26. If you see 26, section 26, it simply says one thing, one line, should be instituted. That's which I think I've already read. Now, stage has come for you. Now you wanted to, yes, institute a complaint. Now, generally things that you look at is, yes, every suit shall be instituted by presentation of a plaint or in such other manner as may be prescribed. In every plaint, facts shall be proved by affidavit. I'll come to the part 2 little later. So you have to institute the grievance by plaint. Now, referredness, let's go to order 6 now straight away. Now, when you are drafting a plaint, remember, you are, most of the times you will not be having enough time, because he comes with a grievance that he is all set to encroach into the property. All cases will not be a promissory note or declaration of title. There are cases where you need to urgently get, even in promissory note, some attachment is required. You have to move it urgently, right? So one constraint that every lawyer has, especially the busy lawyers have, is the time. So you are confronted with that negative factor. Then many a times, especially in mofsal bar areas, the client may not be in position to get the documents and may not be able to give you all details that are required. So these limitations nevertheless are there, but they are not excuses. That's what I'm telling. You can't say that as a client had come at the 11th hour, urgency involved, I am unable to pay. Though normally we say we crave the leave of the court to file additional pleading, but your averment in the plaint or in the written statement in that fashion by itself will not protect. So you have to visualize your role as such an important, such a challenging before you commence. That is why I always tell the young lawyers that don't wait to read the law until you get a until you get a case law, or vice versa. Don't start reading or only when you get the brief on hand. Always keep, whenever you are having time, young lawyers must keep reading and keep themselves abreast of the basics, some important case law, so that as you do not know when a client will come, you will be ready to mold whatever knowledge you have in mind to to suit the case of the client. So a prior preparation is one important factor that would facilitate a proper drafting of either plaint or a written statement. Now, let us start with what is that you need to say in the plaint. What if you don't say when you filed, and what would be its impact? Number one. Number two, for some reason, either genuine or ingenuine, you have omitted to plead something. Can you bring that by way of an amendment? If so, how it can be brought in? These are the next questions. As I said, the first question being how to draft, which we are now discussing. The next question being what is the impact of omission to plead? And then how to cure the omission, that is whether by amendment can we, and if so, what are the implications? Topics 2 and 3 I will carry forward to my next meeting, next discussion, which I request the organizers to arrange. And I would now focus on the first. Right, let's come back. Now we are in the pleading again. Now, what is the pleading? As I said at the beginning, since you defined in order 6, it says pleading shall mean plaint or a written statement. See, both are drafted by the lawyers, verified by the client to be true and correct, and filed again by the lawyer or by the client himself, as the case may be. Not much discussion is required on that. It's just procedural. Now, what is to be pleaded is the most important thing now. Now, for that, let us see what the section says. See, many times I tell, while I was practicing, I had the great fortune of listening to, observing, and at times arguing against lawyers who have put in around 50 plus years of experience at the bar. And those lawyers, I used to get astonished when they start reading the section whenever they start their argument, though these sections are repeatedly order 6, order 7 are very well always repeated as if one knows. They read the section. When we ask them why you are reading, sir, even after having so much of experience, as you might have read it lakhs of times, then they said, every time I read a section, I find something interesting in it, something new in it, something different in it. See, this is that investigative mind is a must for a lawyer. Law is not static, law is dynamic. If law is static and law is what the section reads, I'm afraid the today's situation, the law development in the legal field would never have happened. We have to read in a different manner, acceptable within the framework or the parameters already set. That's the charm of the law. So let us go to the section. What it says: pleading to state material facts, not evidence. So at the outset, we have a bar. Evidence is excluded. It says that don't plead evidence. It has got much importance here We will discuss this in the second session, evidence and pleadings. What it needs to contain is not just facts, material facts, and not evidence. Let us read it in detail. Every pleading shall contain, shall, it is mandatory. That is why omission, whether fatal or not, that can be discussed later. Since it is mandatory, imperative, that every pleading shall contain and contain only a statement in a concise form. Underline the concise form. This requires a lot of discussion, especially in the light of a very recent ruling of 3 learned judges of the Supreme Court, which I will put it before you today. Now, a statement in concise form of material facts on which the party pleading relies for his claim or defense. See, this provision applies to both written statement and plaint. That's why pleading. Whenever I say pleading, it means both, right? Moreover, this section also makes it very clear. Pleading relies for his claim or defense, as the case may be, but not evidence by which they are to be proved. Evidence should be excluded. What evidence? The evidence required to be proved, required to prove a material allegation. So, that part of the evidence shall not be pleaded, but every material statement, every material fact shall be pleaded in a concise form. Now, concise is not lengthy, right? Now, it is said that brevity is the hallmark of a good pleading. But there is no standard formula or a standard view or a standard rule that if the pleading is not concise or it is lengthy, it should not be or it shall not be considered. There is no such. If the case requires detailed material facts, yes, it has to be done. You would agree with me after we proceed with the discussion further, and especially after the rulings, recent rulings of Honorable Supreme Court, which I will try to place either today or in the next session as and when the occasion arises. So, merely because a concise statement or concise form is given, is the word used, it is not a bar. Please have that in mind. But that doesn't mean you make a compound sentences in your plaint and you make a lengthy beating around bush type of facts. All that is not required. Concise means it should strike at first look. One can take within it what exactly it meant, right? So you need to also keep in mind that you should be concise as far as practicable while pleading. This is another limitation for you while drafting. Already one limitation I said, you don't have time, you don't have enough documents at that moment, you don't have all that material fully, but yet you have to file. That is the predicament mostly lawyers will be, especially in the trial court, to when they institute this. So keep this in mind. This is now come to the material facts. Now, what is this material fact? What is not a material fact? Of course, there is neither any formula nor any definition, nor any particular pigeonhole theory for this. Say, yes, if it is this in this, within this corners, this is a material facts. So everything which is not immaterial is material, right? Now, material facts, we have already excluded evidence. We have already excluded evidence. Now we are on the material facts. Since the listeners of my talk today are fairly well versed with the court proceedings, and most of them have even taken a few cases independently, I would divert my discussion to giving an exercise to the listeners, inviting an answer, rather than me lecturing theoretically. So let us take an exercise and see whether the facts pleaded in that particular matter are all material facts are pleaded or not. If you find the answer material facts are pleaded, then you can raise your hands. And others who say that material facts are not pleaded, they can also after that can raise the hands. Then we'll find a solution. So in order to enable you to raise your hands, it is required for me to present the exercise, a small exercise before all of you. Now, so the question is whether in a case to be now given by me, hypothetical case, material facts were pleaded or not. Remember, why this is the importance of this? Unless you plead a material fact, you are not allowed to plead evidence, right? Unless, because no amount of evidence without pleading is considered, will be looked into. Therefore, you need to have a material fact in order to have a evidence let in by you. Now, I'm giving you one small example. It is a case where a person has challenged an adoption. The adoption deed is registered, and that person says that this adoption is invalid. The very suit itself is for declaration. He says that I will read out the averment. He says that the adoption itself is invalid and unsustainable under law. The adoption alleged to have taken place on so and so date has not even taken place. Therefore, the adoption is liable to be set aside. It is a registered adoption. Now, so the material facts here in that plaint is that after describing the factual aspects, A is so and so, B is so and so, A has claimed to have adopted C in accordance with the provisions of the Hindu Adoptions and Maintenance Act, and that was registered, all this claimed to have been done in accordance with the provisions. However, it is registered, but it is invalid as it is violative of the provisions of the Act. It has never taken place. It is fraudulently done in order to deprive me my properties. Therefore, set aside the written statement is just meeting all these set. All these are wrong. We have done the adoption in accordance with law. It's properly done. It is registered. A presumption under law arises in our favor that adoption is valid. Therefore, suit is liable to be dismissed. These are the crux of the material facts of the case. Now, what happened was with these pleadings, the matter went for trial. And during the trial, an application has been filed by the plaintiff saying, after plaintiff was examined in part or so, we filed an application saying, you summon this person is employed in a government department. The adoptive father is working in a government department. So, for an adoption, the presence of the three persons besides the two, that means if a person is taken in adoption, the adoptive parents, if both of them are there, should be present. The persons who are giving adoption, natural parents, if both of them should be present, and that boy should be handed over under this ceremony, a particular ceremony. So the presence of both person who is giving a child in adoption and taking in adoption is a must. So when the plaintiff challenged the adoption, saying that it is invalid, though registered, he wanted to prove that this person was in his duty that day, in his office. Let us say on 1st May 1920, the date of adoption. He files an application and says that summon that person's record to show that he was on duty that day. If he was on that duty that day, there was no possibility for him to be present before. See, we are only talking about the relevancy of material facts pleaded or not. That in that angle only you see, right? And that application was filed. Then the trial judge dismissed that application on the ground that there was no pleading. Secondly, it is belated. Forget about the belated, that we don't know. Let us take a case where he has filed it in time without much delay. But the ground deleted on which it was dismissed was there is no specific pleading that this person was on duty, on work, on particular date. Now, materially, this man pleaded everything. His argument is, I have questioned the adoption. I said it did not take place. I said it did not take place. I said it is invalid. So, the material fact that adoption itself did not take place in pleaded, these are all trivial. They flow from this. How can you dismiss it? That is one argument. Other argument is that he had pleaded, he had only challenged the adoption, he has pleaded that it did not take place. But he did not specifically plead, as usual in the written statement. People would take this, no, there is no specific denial, specific averment like that. He has not said that he is not on duty that particular day. These are the two rival arguments. And the trial court has dismissed it. Now you are before an appellate judge. You are an appellate judge. Now, would you accept the argument that there is no material averment as regards the plea that taken in the petition to summon? The plea is he is not, he was on duty that day. That was, no, those who support the trial judge How many of you support the trial judge? How many of you vary? So I'm unable to see all the faces here. Though I'm in gallery view, again I'll try. I will again go back to gallery view if I'm missing. Okay. So, okay, can anyone tell how many are for and against, so that the or number, basing on the number, we can start? Sorry, somebody can count. I think Mr. Shanmugam can, Shiva Shanmugam, can, Mr.
Yes, sir. Yes, sir. I will do it.
Can you? Because I'm unable to. Gallery view again. I'll go.
Instead, members can already who have chosen to go for hand raise option with them. That should be easy for me to count.
Correct. You are now sitting in appeal against that order. You are all now appellate judges. So what view would you take? Whether you dismiss the trial court order by allowing it, or would you confirm it by dismissing the appeal itself? A small exercise. Sorry if it looks very simple, because as I said, I'm addressing only the youngsters, right? But well, in discussion, we are all students, so there's no problem.
Very true.
What is the majority view?
I think 5 people are for plus, sir.
5 people say that it is.
Yes.
It is order is correct.
Yes, sir. 6 people.
6 people.
And
right.
2 people have given thumbs down.
Rest of them sought adjournment?
No. 2 people have given thumbs down. Not adjournment.
All right. Okay. Fine. So okay. Let 2 who support 2 against say why the permission is denied. After all, a trial court should give every opportunity. Why it dismissed it? It can't be so technical, na? Because you say concise. Because order 6 says concise. You say concise, and you want everything again while dismissing. You say you have to be elaborate. So why not the trial court be wrong? So those who are come on, so anyone can share.
Yes, the point is it was stated that this happened on 1st of May, which happens to be a holiday. It's a Labor Day.
No, it's a hypothetical date I gave. Not that. No. Sorry. I think, yeah. Oh, that 1st May I didn't. It's a working day. It's a working day. Let us take. Sorry.
Okay. I wasn't that impression.
See,
he was pleaded that at that day.
See, why I have chosen this example is in trial court, most of the promissory note cases, if there are a defendant is an employee, say, I am not there, I did not go there, I did not execute. So the question is here, in whatever case, whether that kind of detailed pleading is required, whether it is so material, can it not flow from the broad pleading that it has never taken place, it is sham, nominal, all kind of things, or will it specifically require? Will the trial court be right? Anyone in support of trial court can make, or against can also make.
Since it's a registered document, I think they should have been present before the register on that day.
No, that is also not that. We are only on short point. No, the trial court dismissed on the plea that you have not specifically stated in the plaint that this person was on duty on that particular day. You have said it only for the purpose of this petition while summoning his service record or his attendance record, whatever it is. That particular averment was not there in the plaint. That's why I said constraints. I refer to constraint, time constraint, documents constraints, information constraint. All this backdrop. That's why I gave some backdrop for the discussion. In these backdrops, can the trial court not consider that since he had challenged it, in its fold everything comes? Or trial court is right. No, this is very important. Material fact. We are focusing on material fact. It's a material fact. It should find place. since he did not write in the plaint that the adoptive father was on duty that particular day, there was no possibility for him to go to registrar's office. The truth or otherwise of the statement, we don't go into it. Whether pleading or not pleading is the important thing. So whether it is a material, if it is not a thing, then why? See, it has been taken in the broad sense. He has challenged the very adoption itself. So why not it be considered, or how do we justify the dismissal? Any other view?
Yes, sir. There are two views there.
Yeah.
One, Mr. SPYS has said that crucial evidence to prove my claim has to be pleaded. And the other, Mr. Samir Suryakant Shah, has stated that trial has already commenced. And but when you want to challenge a document, it has to be specifically stated in the plaint.
No, not challenge the document. Please, I will once again make the proposition clear if I have not done so. Sorry, I will again tell.
Yeah.
The simple question is, there is no pleading in the plaint that the person who had taken the boy in adoption was on duty on the date when the alleged adoption said to have taken place. Right? There is no such pleading. Right? However, he had challenged the adoption. He had challenged the validity. He said it did not take place. Broadly, he had challenged. But this particular averment was not there. When the matter came up for trial, he filed an application to summon the service register to show that on the date of the registered adoption, this person, though claimed to have gone to the registrar's office, was in fact present in the office. There is a register. Maybe he was present, may not be present, but his case is that he was present. If you summon that record, it would show that he was present. If he was present in the office, there was no possibility for him to come to the registrar. That could be his argument. We don't go into the correctness or otherwise. What we are, the trial court simply dismissed it on the ground that you have not specifically pleaded that the person who had taken in adoption, that is A, was on duty. As there is no pleading, you can't adduce evidence. On that score, now whether that would constitute a material fact not pleaded, or since you have challenged the very adoption, since it is your case that adoption did not take place, it would take in its fold all these small pleas. It need not be so detailed. Now, which argument is correct? Trial court simply dismissed on one ground, let us state, that there is no specific pleading. Therefore, I am dismissed. So, now the relevance, now section, we are now under order 6. Material fact to be pleaded. Is it so? When broadly you have pleaded every minute material meticulously, then what is the rule of conciseness? It should be short. What is the limit then? Everything. The time taken from traveling also should be pleaded. Every other place to be pleaded. What is that? How far the trial court is correct? What is it? Yes.
Sir.
Yes.
Sir. ఇప్పుడు ప్లీడింగ్ లో క్లియర్ గా కన్సైన్ ఫామ్ లోనే ఉండాలని అన్నారు కాబట్టి ఉండాలి. ఎంప్లాయిడ్ ఇన్వాలిడ్ రిజిస్టర్డ్ డాక్యుమెంట్ ఇస్ ఇన్వాలిడ్. It is implies that it is a concise form in another way. అని నా దృష్టిలో ఉన్నది. సో ఇన్వాలిడ్ మెటీరియల్ ఫ్యాక్ట్ అంటూ ఇన్వాలిడ్ దీంట్లో వర్డ్ ఉంది కాబట్టి, సో దాన్ని ఏ రకంగా కూడా ప్రూవ్ చేసుకునే ఛాన్సెస్ ఉన్నాయి. దానివల్ల అది మెటీరియల్ ఫ్యాక్ట్ ఆ ప్లేట్ లో ఉన్నదని చెప్తున్నారు. ఇన్వాలిడ్ ఇంప్లైస్ దట్ ఇట్ ఈస్ ఆన్ రికార్డ్.
So it can't be dismissed. Your argument is that since he has broadly
cannot be dismissed,
this is wrong. It must be so elaborate that every minute detail. He was working in so-and-so company, on so-and-so date he was in duty. Therefore, there was no possibility to come and register.
Yes.
All that pleadings are not required since he has challenged the very deed and said it has not taken place. It takes in its fold all these trivial things. That is your argument. Fine. Any other view?
Yes, yes, sir.
Yeah, please go ahead.
I think the submission or the statement is sufficient just to state that the person's adoption is invalid. Whether he was in the office to prove that these things did not happen, that can come later in the stage of evidence. Somebody can give evidence, and that could be cross-examined. But to state the very fact that okay, this thing is not valid is sufficiently material in its own standings. That's what I feel.
Fine. So you find that the dismissal of an application on a mere
Is
ground,
invalid.
this particular fact is not specifically pleaded, is
Incorrect. Yes, yes, sir. That is what
you
I
are
feel.
going to allow that and set aside that order. Right.
Yes, yes.
Sir,
Yes.
sir, there are a couple of
Yes,
other
sir.
things.
Yeah.
One, Mr. Chellimuthu has stated the trial court had to allow the application. The existing pleading is sufficient.
Yes.
That's Mr. Chellimuthu's view. And the one, Mr. Galaxy, I don't know whose name it is, he has stated there is no evidence in plaint. Then Mr. Godwin Solomon has stated the attestor gets permission from higher authority to go to registrar's office. Then one, Mr. Madhivanan has stated what is the prayer in the suit. Then
That is declaration.
yes. Then
Well,
other person,
parenting.
Mr. Shivakumar has stated the pleading is sufficient to lead evidence to show that the document was not executed on that particular day. Then Mr. Vaidyanathan has stated no material evidence pertaining to the government raised in the plaint. Then Mr. Senthil Kumar has stated the pleading that the adoption did not take place is itself is sufficient. Hence, in my view, the appeal has to be allowed. Then Mr. Samir has stated the trial court is right for two reasons. The trial has already commenced. No averments about the document. It is general statement that it is not valid. Then Mr. Ms. Jyotirmay has stated, as far as my knowledge is concerned, the trial court decision is correct. Then Mr. Bharani has stated it is not reasonable to summon a document on assumption. There was no substantive evidence to issue summon to the attendance register. Pleading must be supported by arguments and evidence and not vice versa. Then Mr. Tamil Kumaran has stated it is a matter of evidence and all facts leading to the pleading's denial need not be specified in the written statement. Then SPYS has stated when I am challenging the adoption, the appeal should be allowed as the register is a part of evidence to show that the person was not present, as I am not challenging the presence. Then another Mr. KSM has stated specific pleadings is mandatory. Then Mr. Vaidyanathan has stated what are the pleadings that are not raised in the plaint are not to be allowed later. So these are all the summation goes. Then another person has raised that trial court orders liable to be set aside since it is pleaded that adoption deed was not executed through evidence party can prove this plea.
Wonderful views. But one thing I would like to say. See, we are not on the evidence. We are on material facts. If material fact is not pleaded, we are not going into the proof part. Proof will go to the later stage. Here is a case where the trial court said the material fact has not been pleaded. Therefore, I am dismissing it. So that's one. Now, now what happened in the appellate court? The appellate court had confirmed the view of the trial court and said the trial court is correct in holding that the plea that, please again note this, the plea that the person who had taken the adoption was on duty on a particular date on which the adoption has taken place is a material fact. It needs to be specifically pleaded. Since it is not pleaded, trial court has rightly dismissed. So the High Court concurred with the view. It has not taken any deviation. Then matter went to Supreme Court. Now you are in Supreme Court. It comes to you. It has come now. Now, would you agree with both the trial court views or all the same? And say, see, there is a difference between non-pleading and pleading. A pleading is what? Pleading should not contain evidence. Saying that a particular person is on duty on a particular day is an evidence. The argument could be, if I mention all this, they will change the record. There may be something may happen. And why should I say my evidence? Because pleading says write only the facts. The fact is that evidence did not take place. Sorry, adoption did not take place. The fact is that adoption is invalid. The fact is that the persons who claim to have taken adoption have in fact have not done anything as per law. Therefore, it is liable to be set aside. That is the argument. So, saying that that person is on duty on a particular date is only evidence. Why should I plead? One breath you say evidence need not be pleaded. Need not be pleaded. But with the same breath you are saying, no, you have not pleaded so. You are getting confused between material fact and evidence. That is the argument before Supreme Court if it is so. Then what would be your? If you are a Supreme Court judge, would you set aside the High Court order as well as the trial court order? Don't say I would remand it back. That will not solve the problem for us. You have to decide.
Yes, the orders have to be set aside.
So you agree, you say that it has to be set aside for the same reason.
Because what has been pleaded, the fact is that what has been pleaded is more than enough for him to prove on trial. Because the case of the defendant is there is a registered document, which means he should have normally be presented on that day before the registrar.
No, that's okay.
That is the defense.
Let's go into that presumption part. Maybe simple point.
He need not. Yes, whether he attended the office on that day or
for
not.
example, a promissory note. Let us again discuss. This is very, very, though looks simple, this is a very useful proposition because I said I'm addressing young lawyers who are in the trial courts. The pleading, for example, take a promissory note. A person denies the execution. Once an execution is denied, the burden shifts on the suitor. Right?
Yes.
And the defendant wanted to file a petition saying that on the date of promissory note, I am on a duty or I'm in some XYZ place. There's no possibility for me to go to the plaintiff's house or a place where the plaintiff claimed to have land and sign the promissory note and take money. And he files a petition in reverse. Show that he was at X place and not at the place where the promissory note is eligibly executed. Without making any statement in the written statement that he was present at X on that particular day. Therefore, there is no possibility to be at the home of A and execute promissory note. But he takes a plea that I have not executed the promissory note at all. In all these cases, merely because the pleading that I am not at the place where you are claiming that I am present, but I am X, to prove that I am at X place, please send summons. Then the magistrate rejects saying, you have not stated in the plain or written statement that you are at X place. Therefore, I am dismissing. That's all, only one ground. In fact, he dismissed on that ground. High Court confirmed that view. Is it good for you if you are in Supreme Court to accept it? Good or bad, leave it. Is it under the law? What view would you take? Because see, you are to say evidence and fact, whether this is evidence or not. You may argue, no, bringing him to the court to prove a fact that he was at X place is evidence. So why should I disclose my evidence? Law doesn't allow. Ask me. I'm not under obligation of law to disclose it. I'm exempted. These are the arguments that is possible.
Yes.
The concept of pleadings is only to give an opportunity for the defendant to defend. So in this case, I think the pleadings is more than enough for the party to prove it at a later point of time by evidence that he was not available on that day.
Fine.
Even though there's no material, even though there's no specific pleading on that aspect.
Any other view?
Yes.
Yes. What is that?
Definitely, Supreme Court has to set aside the order of the High Court, and the trial court should give an opportunity to the parties is concerned to let him evidence. So, in the evidence only, it will prove whether the parties, all the parties were present.
So
Now there is a pleading in the plaint.
Without pleading.
No. There is a pleading in the plaint
There's
that
no
there was an
pleading, no.
adoption.
You have not pleaded.
No, there was an adoption. Presence of the parties are concerned, there is no pleading. During the trial only it will prove. During the trial only it will prove whether the parties were present or not. All those things are the opportunity should be given to the parties is concerned to let them evidence.
Okay.
Then only it will prove.
Okay.
Simply because he has not stated the plaint, the trial court cannot simply reject the petition. Therefore, my view is concerned, the Supreme Court definitely to set aside the order of the High Court, remand back the matter, give an opportunity to the plaintiff is concerned to let him evidence. That is my.
So you hold that you are not in favor of the trial court. Fine.
Yes.
You say that is evidence. It is not pleading is not required.
Yes.
All right.
Yes, there is a specific pleading that there was an adoption, and the registration deed also is there. Registered adoption deed.
They are all admitted. He says,
yes,
this particular part is not pleaded. Therefore, you cannot summon. The petition is dismissed. All
no,
right.
that is a wrong view. That is wrong. Opportunity should be given in the during the course of a trial only. It will prove whether the parties were present or not, and all those things.
All right. Any other view before because time.
Yes, sir. There is one person, M30, has stated that it is not a material fact but an evidence. So no need to plead in the plaint. Appeal may be allowed.
Fine. Okay.
And one.
Any other view?
Om Prakash, what is your view? You are simply keeping quiet. Senior advocate.
You have said specifically he would like to have the juniors to participate more. Juniors. So we will also sit and learn, that's all.
And there's another view, sir. Mr. Godwin has stated the plaint has to be concise of material fact and it need not plead about evidence.
That's right. Okay. All right. If because we also have the time limit and I have exceeded it. Before I conclude, let me tell you what inspired me to put this question. Two things. First is that I'm addressing the young lawyers. Secondly, these young lawyers are the lawyers who are practicing in trial courts. So then thirdly is the recent ruling of the Supreme Court in this regard. The exercise I have taken it is from that judgment. I will now give you the outcome of what the Supreme Court has said. This case was decided very recently in November. However, this is stated to be a non-reported judgment. Try if you can download this, or I will mail it to the organizers, Mr. Om Prakash or Mr. Sharma, then can forward it to you. The Supreme Court has confirmed the view of the trial court as well as the High Court and said a material fact has not been pleaded. The material fact, according to the Supreme Court in that case, is that he had not specifically pleaded that the person who claimed to have taken adoption was present at some other place, though he had pleaded that adoption is not validly done and has not taken place, etc., etc. See to the extent the law has changed. Please note the citation before we go. It is a case between Biraji, B-A-R-A-J, Biraji at Brijraji, B-R-I-J-R-A-J-I, and another versus Surya Pratap and others. It is a civil case number 4883 to 4884 of 2017. Justice Subhash Reddy has delivered the judgment on behalf of the three learned judges of the Supreme Court. So now, see this today, the Supreme Court, three judges' judgment, which I will pass on, it can be circulated, has taken a view. Maybe people say it's a very a view that would restrict the opportunity to the plaintiff to lead evidence. But we can't help it. The law today is that if we go by this judgment, though we have earlier judgments, I'm supporting the view of those who have argued against the order of the trial court. There are views. You will find many. But I've taken to the best of my study, limited at least, and the very recent ruling. Please read. It's only 10 paragraphs, very simple judgment. Dismissed on the ground. They have not gone into earlier precedents. But this is the latest law. So if this is the case, remember, if you are drafting a written statement for a defendant in a promissory note case, simply denying execution, at best relieve you of the burden of proof, and as it shifts onto the other side, it will not relieve you of the liability, because you are not going to succeed on those pleadings. You be as clear as possible in the trial court. After all, being more elaborate is never dangerous. But I'm not encouraging prolixity in the pleadings. But material facts, like if you are saying, I have not executed the pronote on the day, there should be some reason, no? Unless you take it's a forgery. Forgery is different. Then your signature will come. You just take a plea that I have not executed the pronote. Then your signature is there. You are not, that signature, whether it's yours or not, that can be tested. And what is the other reason for saying that? You say that I'm in office, I'm in some marriage, somewhere, some city, some outside India. Unless you say that also in your written statement, tomorrow in evidence, you can't establish that. If we go by this judgment, the three-judge judgment. So that concise, don't take it in literal meaning. Try to be as clear as possible in your written statement as well as in the plaint. In the plaint, while challenging a sale deed, simply say that I have not executed it. If you have some ground to say that, there is no possibility for me to execute it as I was elsewhere, somewhere. Otherwise, while leading evidence in support of that plea, you may confront with a problem. You have not pleaded that you are at some place. So why should I allow you? Because settled law being no amount of evidence without pleading is admissible. Therefore, where are you today? That is why in the trial court, read order 6, and then try to put all these possible things which you are capable of proving, either in defense or to destroy the case of the plaintiff in the plaint or the written statement. Otherwise, you will have a problem, like in the case that I have just cited. Okay, we have other way, because every rigid rule has a loophole, or where there is a lawyer, there is a way. Like where there is a lawyer, there is a will, W-I-L-L, that will under the succession, right, where it is required. Now this is another. There is a way under the law. Can we bring it by way of an amendment? Can you not amend? Supposing in this case, the petition is dismissed. But the fact of the matter is, official record is there to show that that person was there. Can you seek an amendment to the plaint or the written statement, as the case may be? Okay, you omitted it. Whether the omission debars you totally, can you improvise it? This is like damage control. So I would first tell you, avoid damage by considering order 6. In case inadvertently, as it is common in this profession, to occur some kind of damage here and there, unless it is irretrievable, then we have to think of damage control. Now in pleadings, what could be the damages? Omission to plead, one. Then some things have come to light subsequently, which we were not expected to do. Then that way can the pleading be improved, either plaint or the written statement. This will be our discussion next time. I will try to, now this case law, I will send it and then you can read. And then next we will discuss about, in case we are unable to plead something. Now today we have seen the importance, fatal. I still have my doubts whether it is required to go in such a detailed way or not. Is it not enough? Say, concisely state, this man have not, it is valid, it's invalid, it takes in its fold everything. Suit itself is for declaration. That adoption is illegal, invalid, all that. Then I'm saying specifically what more. In a declaratory suit, the onus is on the suitor, right? All kind of things. So he can, to discharge this burden, he has asked for record to be produced. Is it that? If he says he is present on duty, will the law require, no, which organization? What is his designation? Where is the place? You have not mentioned those. Therefore, we are not allowing. No, what is the limit? What is scope? Please ponder over. These questions, today, a kind of judgment will sometimes create havoc if that is placed before. It creates havoc. If it is helpful to the plaintiff, it is havoc to the defendant. So you have to get over. Therefore, focus. Young lawyers, please focus on this. There is abundant of case law on order 6 rules. You must read that. You must understand that. Discuss with seniors. Then your foundation will be strong. Because you are a plaintiff, you are a defendant. Your role changes. Right? So, please focus on that. This is a very simple topic, elementary topic. I know. If everyone can, or most of you here, or all of you here can speak on it. But why I have chosen it is, this is the importance it has. The pleading, that is what the foundation. Law today, the 3 judges have felt. They never took it up, okay, it's a trivial omission. We allow him to amend the plaint and then come back. Like, no, they conferred with the High Court, concurred with the trial court. So this is, okay, we will defer. Acha, I'm sorry, any questions in today's thing? If there is time, I'm not sure. I always violate one thing, this time limit. That is, I forgot time when I'm. 2 things I used to violate while I was in DRT. The queue line, though I wanted to stand in the line, I used to enter DRT by violating a rule and used to preach everyone, don't violate rules. The first violation was getting into the lift, bypassing others who were standing. I don't know, that I tried to avoid, but I failed. So today again I violated time. Given time limit, it is 12:20 now. So any questions if now time permits, otherwise keep your questions, I will answer next time. Thank you once again for in this pandemic time, you have come and have chosen to listen to me. I'm so pleased to see so many new faces. So many faces whom I used to see every day. So today I could see Mr. Om Prakash, Mr. Shanmugam, Mr. Ramakrishnan, Mr. Rajashekar, and many others. Of course, full gallery view I'm always missing, otherwise I would have named. I'm only getting a limited view of them. So hope I get gallery view next time. And I wish you take the courage of attending my next meet. and then give me an opportunity once again to see you and share some of my random views on this topic. Thank you. Thank you very much.
Thank you, sir. The most number of questions are regarding the next session, the details of which will be posted on the WhatsApp group. The judgment that you referred to has also been posted on the WhatsApp group. The citation for the same has also been posted in the chat box here for anyone's reference. I now invite Mr. Murthy, advocate, to render the vote of thanks for the day and close the session.
On behalf of the study circle, it's my pleasure to thank the speaker of the day, Dr. Badarinath, our former PO, DRT1. On behalf of the participants, I take the liberty to convey to the speaker that today's session is not only meant for the young lawyers, as it was claimed by the speaker, but the essence of today's session will be useful and beneficial for one and all. We all know about the speaker's in-depth knowledge in civil law as a practicing lawyer before him in DRT, and also from his previous sessions during last year lockdown. It is yet another valuable knowledge share by our speaker, and I thank him for accepting this session and sharing his in-depth knowledge and making it a wonderful and useful session. Before concluding, I, on behalf of the study circle, request the participants to note that our next session is scheduled on next Tuesday, that is 25th of May, and request all the participants not to miss the same. Thank you, one and all.